I hope this finds you well. The Supreme Court heard oral arguments in Voisin et al. Versus the United States on February 29th, 2016. This oral argument was special because it was the first time Justice Clarence Thomas asked a question in 10 years. Justice Thomas and Justice Scalia sided together on many opinions. On Monday, the 29th, seated next to a chair now covered with black memorial drapery, Justice Thomas questioned an attorney. Oral arguments within the Supreme Court are often limited on time. In those fleeting minutes, the attorney attempts to persuade the justices to rule in their favor while handling a barrage of questions from the justices. I say this because this has been one of Justice Thomas's reasons for not asking questions during oral arguments. He has taken much heat from the mainstream media over the years, with one reporter going so far as to accuse him of dereliction of duty for not asking questions during oral arguments. The case being argued concerns whether a prior domestic assault conviction based on reckless conduct qualifies as a misdemeanor crime of domestic violence. If it does qualify, then the prior misdemeanor convictions of the plaintiffs would prevent them from ever owning a firearm. I've linked the statute at issue in the description below. February 22, 2006 was the last time that Justice Thomas asked a question at oral argument. The next time Justice Thomas would speak at oral argument was on January 14, 2013. In that oral argument, Justice Thomas briefly made a Yale-Harvard joke, but asked no questions. I've linked those two transcripts in the description as well. It would seem fitting in Justice Scalia's absence that Justice Thomas would now choose to ask a question at oral argument. Since the case at bar involves Second Amendment rights, an issue that Justice Scalia felt strongly about, and even authored the opinion to the landmark case of District of Columbia versus Heller. But that's just my guess. Well, enough of my rambling. The following audio is the line of questions asked by Justice Thomas to Attorney Eisenstein. Attorney Eisenstein represents the United States in this case. Thanks for watching, and let me know in the comments below how you think the court will rule, or should rule, in this case.
If there are no further questions.
Ms. Eisenstein, one question. Can you give me, this is a misdemeanor violation. It suspends a constitutional right. Can you give me another area where a misdemeanor violation suspends a constitutional right?
Your Honor, I'm thinking about that, but I think that the question is not, as I understand Your Honor's question, the culpability necessarily of the actor in terms of the offense below.
Well, I'm looking at you're saying that recklessness is sufficient to trigger a violation, a misdemeanor violation of domestic conduct that results in a lifetime ban on possession of a gun, which at least as of now is still a constitutional right.
Your Honor, to address—
Can you think of another constitutional right that can be suspended based upon a misdemeanor violation of a state law?
Your Honor, while I can't think of specifically triggered by a misdemeanor violation, other examples, for example, in the First Amendment context, have allowed for suspension or limitation of a right to free speech or even free association in context where there is a compelling interest and risks associated, in some cases, less than a compelling interest under intermediate scrutiny.
How long is this suspension of the right to own a firearm?
Your Honor, the right is suspended indefinitely.
Okay, so can you think of a First Amendment suspension or a suspension of a First Amendment right that is permanent?
Your Honor, it's not necessarily permanent as to the individual, but it may be permanent as to a particular harm. And here Congress decided to intervene at the first instance that an individual is convicted of battering their family members because it relied on substantial and well-documented evidence that those individuals pose a long-term and substantial increase.
So in each of these cases, did any of the defendants, or in this case petitioners, use a weapon against a family member.
In neither case did they, but these petitioners...
So that the suspension is not directly related to the use of the weapon. It is a suspension that is actually indirectly related or actually unrelated. It's just a family member's involved in a misdemeanor violation, therefore a constitutional right is suspended.
Yes, Your Honor, but I believe that in terms of the relationship between Congress's decision to try to prevent domestic gun violence and its means of doing so.
Even if that violence is unrelated to the possession of a gun.
Well, Your Honor, I think the studies that Congress relied upon in formulating the misdemeanor crime of domestic violence ban were directly about the use of a gun, because what they showed is that individuals who have previously battered their spouses pose up to a 6-fold greater risk of killing by a gun their family member.
Well, let's say that a publisher is reckless about the use of children in what could be considered indecent displays, and that triggers a violation of, say, hypothetical law against the use of children in these ads. And let's say it's a misdemeanor violation. Could you suspend that publisher's right to ever publish again?
Your Honor, I don't think you could suspend the right to ever publish again, but I think that you could limit, for example, the manner and means by which
So how's that different from suspending your Second Amendment right?
Well, Your Honor, I think that in terms of the compelling purpose that was identified here, which was the prevention of gun violence and the individual nature of the underlying offense. So here, this isn't a misdemeanor crime directed at any person at large. These are misdemeanor batteries directed at specified members of that individual's family.
Would you have a better case if this were a gun crime?
Your Honor, I think it would be perhaps a better case, except that the evidence that